Hi, I'm Donald Goldbloom, attorney at law. I've been helping clients with legal matters for over 40 years. While this video serves to provide some general information around the practice areas discussed, it should not be taken as legal advice and should also consult directly with an attorney to make sure that the specifics of your particular matter match up with the various laws that are applicable. The choice of an attorney is an important decision and should be given careful thought before deciding on who you may wish to hire. If you need representation or have any questions, don't hesitate to contact me at 301 895 5240 or visit our firm's website at www.goldbloomlaw.com. That's GOLD, like the metal gold, and Bloom, BLOOM, like a flower blooms, goldbloomlaw.com.
Today I am joining attorney Donald Goldbloom, who is located in Grantsville, Maryland. He's been practicing for over 40 years. In today's video topic, we are going to be going over the criminal process. So Don, welcome and thank you for having me.
Glad to be with you.
If I've been charged with a crime for the first time and I am going to you, what does that process look like? I know you hear from probably many clients who come to you that this is their first time ever being charged and dealing with the criminal process. What does that look like? Walk me a little bit through what that process entails.
The first thing I'm going to do is make you comfortable. One of the things that I do as a lawyer is to not judge, is to name, not blame. Sometimes when you are charged with a criminal offense, it might be something you didn't mean to do, or you got with the wrong people. And so what I want to do is just have you sit with me as if we're sitting around the fireplace or a campfire in a relaxed atmosphere where you are telling me your story. Because then it helps me to find all the things that had gone on that particular day or evening. And when we are comfortable with one another, then I can give you the most help.
Does your process differ, at least the initial part, whenever you're kind of onboarding and talking to someone, whether the crime is a misdemeanor or a felony offense? Does that kind of change your tactic when handling anyone, or as they come in, is it kind of the same, sit down and chat, regardless of kind of what they may be going through?
Well, obviously, the more serious the crime, the more ramifications, and usually the more uncomfortable my client's going to be. But the process is generally the same in terms of gathering information. I want to get all of the background. I don't want the client to leave anything out. I'd rather the client be more detailed rather than less detailed. And again, we want that client to be comfortable, because sometimes a client will be ashamed to tell me something, and what they're ashamed to tell me is the most crucial thing. Now, getting into the distinction between misdemeanors and felonies. Misdemeanors are usually more amenable to alternative resolutions. Um, Maybe only about 10% of my cases would actually go to a full trial. So oftentimes we can resolve things um, through negotiating with the state's attorney, because from our perspective, we want to rehabilitate, and we go towards the correctional part of the criminal law. The state attorney is trying to protect society, trying to make sure that crimes don't reoccur. So it's where you have the intersection of the philosophy of crimes not reoccurring with the idea of correction and changing behavior, that we have the most efficient legal system. Because if they're coming through my office and we can get this so that this doesn't happen again, or we ameliorate the situation, then the state's going to be protected because we've reduced the criminal behavior. So that's the ideal. So that applies to misdemeanors and felonies. Sometimes some of my most difficult cases are what I call backyard neighborhood cases. I would rather sometimes talk to a stone cold murderer than a neighbor who says, I'm the most perfect citizen in the world, but I can't get along with my neighbor. We've been fighting like Hatfields and McCoys for the last 15 years. I might spend double my interview time trying to solve a neighborhood issue as opposed to talking to a murderer.
Having dealt with both good and bad neighbors in my life, I can safely say I think I can agree with you, and I understand that point of view 100%. It can definitely be a lot easier to deal with someone who can just be more straightforward and just kind of has the one case than kind of two people butting heads and trying to deal with that for for sure. If you don't mind providing some insight into this, just because this is more of maybe even a personal question for me. So I'm initially from Pennsylvania. So the grades that we go through misdemeanors and felonies are basically three tiers for felonies and three tiers for misdemeanors, but other states do it differently. What do the misdemeanor and felony grades look like in Maryland, where you practice? Are they separated into three tiers? And then with kind of minor cases like infractions as a separate, how does that look for you?
It's crime specific. Uh, so, like, you might have first degree assault and second degree assault. Um, and the first degree assault would be your felony, your second degree assault would be your misdemeanor. But it would be crime specific. And then within the felonies, you might have different levels or different elements to make up the different parts of the charge. But we don't have blanket classifications, it's more crime specific. Um, and of course, the more severe the offense, the greater the penalty is going to be. But generally, we're just make the distinction overall between felonies and misdemeanors.
Moving on from this point as we get into the another introductory period of cases, um, preliminary arrangements and bail hearings. What do these look like for clients, and what are they in general?
Well, it depends on when I'm hired. I'll just go over it in general. Uh, the process, what happens when um, it's you're arrested and you're charged. Um, there is two types of arrest. One we call on view, and the other we call arrest subject to an arrest warrant or a criminal summons. The on view is where a crime is in process, the police are called, and the policeman or law enforcement authority is actually seeing it, or the crime is in the process of being committed, or you're in hot pursuit. It's an ongoing situation. Then you can make a direct arrest on what we call a statement of charges. If, however, um, let's say a domestic assault has happened and the officer's not there observing it, and the person, the husband or the wife that has been beaten, calls the police, then the police will have to suggest that they go to a judicial officer, either a judge or a court commissioner, to then have a warrant, arrest warrant, issued. And the warrant is issued based on probable cause, which means it's more likely that the crime occurred than it didn't, and more likely that the person charged with committing the crime committed it. And if it's more likely on both of those issues, then there's a finding of probable cause. Upon finding probable cause, then a warrant is issued and somebody is arrested. There's also what we call a criminal summons, where they're not actually arrested, but they are also given the same probable cause that a crime was committed and this person is likely to have committed it, but it's a less serious crime, usually misdemeanors. Could be some kind of a neighborhood dispute or something. They don't really want that person to be handcuffed and go to jail. They just simply issue a criminal summons and then they go to court. And they can still go to jail as a result of being found guilty, but they're not going to have that process of pretrial detention and bail review and initial appearance. But most charges have come in through that initial appearance and a review for bond or being held without bond. Very few cases really go that criminal summons route for the most minor things. Most cases are coming through that arrest process, either through arrest warrant or on view. Now, we don't have a lawyer sitting at every corner 24/7. So obviously, I'm usually getting the case once they have been charged, they've been handcuffed, they've been taken to the station, they've been read their rights, they've given, hopefully read their rights, uh, and they've been given their papers and they've gone through the process. The first stage for a lawyer to become involved as is when the defendant is brought before a judicial officer. In Maryland, usually the officer of first appearance is going to be what we call court commissioner. And that is what we call a critical stage of the proceedings. Constitution requires that a lawyer be present, or that you have the right to have a lawyer present. The lawyer doesn't need to be present anywhere, but the defendant has a right to have the lawyer present at each critical stage. So the first step in the critical stage of the proceeding is the initial appearance. And that's where the judicial officer, usually a court commissioner, will determine whether or not that person should be released or held on bond or held without bond for the judge to review. The more serious cases, the more likelihood that there's a flight risk, then the more likely there will not be a bond put on by the commissioner, which in some jurisdictions you would be sort of like a magistrate. It would be held for the full judge at the next sitting of court, which is usually the next day, or if it's a holiday, it would be the next sitting of court. But the minor cases and the ones where the flight risk is low, then often the commissioner will put a bond or decide that a bond is not necessary, release the person on their own recognizance. And so, or what they call an unsecured bond, which means that if they don't show up, they have to pay them a certain amount of money, but if they do, then they're not responsible for it. There's various types of what we call pretrial release. The commissioner would also impose conditions. Pretrial release, if it's a neighbor fighting a neighbor, well, then you're not going to have contact with that neighbor. If you violate those conditions, then you can be brought back in for violating your conditions of release. So the lawyer usually doesn't get the case until that person has gone through that initial appearance. They have the right to call a private lawyer. I can get called at 4 o'clock in the morning by somebody, and we can do those initial appearance procedures telephonically. So I can be talking to the judicial officer at 4 o'clock in the morning and say, yeah, my client's the most wonderful person in the world. He should be able to be released on his own recognizance. It's just a minor neighborhood dispute and this thing can be resolved. But typically people aren't calling their lawyers at 4 o'clock in the morning. Somebody is indigent, which means they don't have money and they qualify for a public defender. Then there is a public defender, court-appointed lawyer through the court at the initial appearance and then through the public defender's office thereafter if they don't have money to have their own lawyer. Having said all of that, when I usually get the case is at the actual bond review before a judge when they haven't been released, or more typically they've posted their bond or whatever, and then they're coming into my office. And if they're held with on a large bond or without bond, then it's usually going to be a family member or somebody in that client's purview that will be contacting me, and then I would go to the jail to interview them. So a lot of things can go down before I even get it. They can lie about a confession that they should never have talked about, even though they've been given their rights. And so what I have to do is try to pick up the pieces of things that might have gone wrong. But as a defense lawyer, the earlier I can get on a case, the better.
No, that sounds good. There's a lot of information that you provide there, and I think it was a very good overview of the process. And obviously, stuff varies from state to state, so it was kind of interesting to see things and hear from your perspective and how you handle cases. One or two things that you mentioned that actually I want to touch on just real briefly a little bit more if we can. In today's day and age, post COVID and whatever, you mentioned that you have the option potentially for a telephonic conference for the initial. Does that apply to all case types of the criminal spectrum, or is it more so usually for misdemeanor lesser offenses that's an option? Or what does that look like from your perspective? Because I think that it's a great asset that people can access now and utilize, especially if possibly I've committed a crime in Maryland, but I'm living in Pennsylvania. I know at some point there's a very good chance I will have to make a court appearance in Maryland. But in the meantime, if there is a telephonic option, even for the initial phases of my case, that's very very helpful for I think me and other people to know.
Yes, you can be first degree murderer and still have the right to have your lawyer there telephonically at your initial appearance. Now, I can tell you, if you're a first degree alleged murderer, is what I should say.
Right, right, right.
By statute, that initial court officer, that we call a court commissioner, does not have the power to release that person pre-trial because of the seriousness of the case. However, they still have their initial appearance, and in their initial appearance, they are still given their charges, and you still they have an opportunity to request a preliminary hearing, and there are legal processes that go on. And with the rule changes post COVID, actually, this rule was introduced before COVID, but more widely exercised after COVID. People do have a right to have their private lawyer, that they wake up at 4 o'clock in the morning, and maybe somebody that does heavy criminal work, particularly downstate, they're used to getting a call from a murderer that is somebody's alleged to be a murderer at 4 o'clock in the morning, and that person can join in on the initial appearance. And if they don't have money to hire a lawyer, or they might wind up hiring a private lawyer through their contacts and sources, but based on their income, they qualify for a public defender, then they get a court-appointed lawyer. There are court-appointed lawyers are on duty 24/7, and they call the lawyer that's on duty. Or in the larger jurisdictions, that lawyer is personally there. In the outlying jurisdictions, usually it's telephonic, and that lawyer can be present at the initial appearance. So, to answer your question, doesn't matter how serious the case is, that first step, that initial appearance, is the first part of the critical parts of the proceeding where constitutionally you have the right to have a lawyer be with you. Now, it's a practical matter. Very few lawyers are up at 4 o'clock in the morning, and it's usually a pretty routine procedure, but they do have the right to have somebody there. Again, just if I'm talking to people, the earlier the attorney is involved, the better.
I like that. I like that. That's something that has been implemented because I can't speak for the full extent of Pennsylvania and other states, but I know from speaking with other attorneys and stuff, it's definitely not always the case for what they do. They're making their appearances in person, and I think it's a really nice asset, like I said, to have and to be able to provide for clients or anyone charged that you have that option to make that telephonic appearance. And I hope it's been a great aid to you as well when dealing with clients and being able to juggle your line of work and in various cases as well.
I do need to say though that the appearance is usually, that initial proceeding is usually limited to just that proceeding. So, like, if I'm appointed by the court, for example, for an indigent client, I specifically tell the client that I am only there to help them through that initial proceeding, and then they'll have a staff public defender represent them from there on. If I'm a private lawyer, I will enter my appearance for that initial appearance telephonically, but that appearance will not show up usually as an appearance on the whole case without me then following it up and putting in a written appearance for the case in chief.
Gotcha, gotcha. So that's only so it's only at the very beginning, basically the first step of the process. As you actually get deeper into the case, stuff starts to shift a little bit.
Correct.
Okay, okay. Um, and real quick as well, just touching on another subject, bonds for Maryland. How do bonds work in terms of just payment and obtaining a bond? I know certain states you can pay. I think it's like 10% of the bond in order to be released. How does that look, and how does the bond process work for Maryland?
Well, you have several levels, and I'll just go over the levels. The more serious the crime, the less options you're going to wind up having. But I'll just go through them all. And then uh, the first level is simply recognizance. You can be released on your on your own word. Your word's your bond, that you promise that you will show up. Usually, it's for the smaller crimes. It's where the flight risk is low. There's not been prior failures to appear in court or anything that would look like that person would flee. It's usually people with strong family ties in the community and a strong likelihood that they're going to appear in court. We don't want to punish people pre-trial just by having a large bond. Sometimes, if people are held on bond, when they actually get to the final trial, they might just get time served. Sometimes they might serve time that they wouldn't need to have served, um, but for the fact that they're not raising their bond. So in Maryland, the first priority, well, the overall first priority is the safety of the community. But with the more serious cases, you're not having some of these options. But other than the safety of the community, your priority is not to punish the person, but to make sure that that person appears in court. So the presumption in the smaller cases is to take that person's word, but there has to be some basis for ties to the community. The more ties you have to the community, the longer you've been employed, those kinds of things, the more likely that you're going to appear in court. And to back up the safety of the community, you have pretrial conditions, pretrial release conditions. So you have no contact with the alleged victim. You have to report maybe to a pretrial release officer. There are various things that they would need to do, but they're getting out on their own recognizance, and there's no bond. The next level is what we call unsecured bond. So maybe they need a little bit of motivation other than just they need to come back to court. And so let's say we put $1,000 unsecured bond. If that person fails to appear, then they will be responsible for, like a civil judgment, for that $1,000 penalty. They'll have to pay that to the state because they failed to appear in court. And then there's also secondary criminal implications. If it's a misdemeanor, it's a smaller penalty. If it's a felony, it's a larger penalty. But you can have a fine and incarceration for the crime of failing to appear in court. So they're always advised of those consequences if they're not following it up. The next level up from there is what we call a percent bond, and that's where you're talking about your 10%. Um, the law doesn't say it has to be 10%. It could be 50%, 5%. Usually, though, they're talking in terms of 10%. And so if my bond is $1,000 and it's cash bond, in other words, I have to put up the cash, but I'm only putting up 10%, then I give 10% to the court. The other 900 would be due, like the unsecured bond, if I fail to show up. Uh, then the next one would be a full bond. Let's say it's $1,000 and I have to pay it in full. No 10%. I just have to pay it in full. Now, if I don't have $1,000, I can hire a bondsman. And the bondsman will put up the full amount. And then typically the bondsman charge 10%, but I don't get that 10% back. If it's a full cash bond and I've hired a bondsman, then I give that bondsman 10%. That's his fee to put it up for me. Whereas if I get a 10% bond by the commissioner, I avoid the bondsman and I do get that $100 back out of the $1,000, that 10%. I'll get it back but when I appear in court. So there's recog, there is unsecured bond, there's a percent bond, and then there's a full bond. And full bond, then you're usually getting bondsman. In certain cases, you can put up property as opposed to cash. It's very difficult a lot of times for the courts to manage that. The courts aren't into the business of doing title searches and whatnot. So usually you're going to have a cash bond rather than a property bond, but there is provisions for that. As you get into these larger cases, you're seeing high profile cases. People are not going to walk around with $500,000, but they might have a $500,000 property they can put up. So there is a provision for it, but in the typical run of the mill cases, you're usually looking at cash bonds. Then there's no bond. And there are certain statutory reasons. If you have committed a violent crime, then you're committing a new violent crime. If it's a very serious crime, there's a risk of either by statute or just by the judgment of the judicial officer, they feel that there's either a severe flight risk or there is a danger to the community. They will not put a bond on it at all. They will hold it to the judge, not just the initial appearance officer, which is the court commissioner. They'll wait till the next sitting of court, and then the judge would then make a determination as to bond. And on the very serious cases, sometimes it's no bond at all.
All right. So the next topic that we are going to cover, or that I would like to cover in the criminal process, is the discovery process. And the discovery process is actually a term that is used in a multitude of cases. It's not strictly tied to criminal cases, but it is a very important part of the criminal case process. Because this is the part where you're going through and actually you're reviewing documents, evidence, and everything. So it holds a great deal of weight for these cases. So can you talk to me and the listeners a bit about the discovery process and what that looks like from the criminal process perspective?
Well, first of all, as I said before, the earlier you get on a case, the better. So if you're on the case early and you have the resources either through public defender's office and their investigative arm of that office, or you're a private lawyer and you have a private detective, the quicker that you can get to the alleged crime scene, or you can take your own photos, or you can get reconstructive person there to whatever your expertise is in terms of interviewing potential witnesses, people that are involved in what went on. The quicker you do that, the better, because people's memory tends to fade and get less accurate the further you are from the time that the occurrences happened. So some of the discovery is just by shoe leather, the old time books that you read on solving mysteries and things like that. It's just Paul Drake going out there and doing what he needs to do. But in this day and age, as a practical matter, we're not having complex investigations on the run of the mill crimes. What we're looking at is the police report. And we do talk to the witnesses and do the best investigation we can, but we're not going out on every run of the mill crime and doing on-site inspections and whatnot. But the serious cases we are. So the next step in discovery, other than physically doing your own investigation, would be through a process of disclosure through the state's attorney's office. And there are questions that you ask and requests for production of documents. So, for example, they have to tell you about any exculpatory evidence. So if there is something one witness comes up and says, "No, he didn't do it. This other person did it." That needs to be disclosed as something that would be exculpatory. Um, but there's all kinds of information. A lot of times, the officers have body cams. That's much more prevalent today than it was before. You have surveillance pictures. And again, if the state has access to that, then we would have access to that through pretrial discovery. The whole purpose of discovery is to know in advance what's going on, because real law does not act like Perry Mason. You don't usually have the witness that straightens everything out come up in the middle of the end of the trial and solve it. It is done through hard work ahead of time, and then usually with a good discovery process. Sometimes cases will resolve. They might go away because the state doesn't have the case they thought they had. So it is incumbent upon being well prepared. And you do this through, sometimes you do it through oral deposition. More typically, it's done through written um, questions and requests to produce documents. So that you're getting the witness list of the people that the state is going to call against you, the whatever evidence they have. If it's chain of custody for drugs, you're entitled to know what that chain of custody is. You're entitled to you'd be able to have your own experts to examine the gun to see if that might have been uh, an element in it. So you have the tangible physical evidence that can be reviewed, and also videos and documents. Is typically what happens in pretrial discovery. Now, we as defense lawyers have an obligation to disclose some things too. I won't get into the details of it, but it is a two-way street so that we do have a fair trial.
Moving on from discovery, as we're approaching hopefully kind of the end and going through further in the case. Most people focus, and when they think about, I think, any attorney's job and for the criminal process, you're sitting up there in the courtroom, a big trial's going on, surrounded, you have jury, all this. But before you even get to the trial process, and I think a lot of people don't even necessarily think how few of cases actually get to that point for trial, because trial it's a big deal and there's a lot of work that goes into it. For criminal cases, you have something called plea deals. Can you provide an overview of plea deals, and tying into that, why should or shouldn't someone consider taking a plea deal?
Well, I'd like to call it a plea agreement rather than a deal.
We'll use plea agreement. Okay, yes.
Because the deal kind of sounds like, oh, the old time gangster movie, quid pro quo, and
Right, right.
you're just, oh, you're really guilty, but you just kind of, want to get out of doing it. But a plea agreement um, is a two-way street, because for the state, for the purpose of the state, they want to protect society, and it takes a lot of time to put on a case, and so therefore there is a motive for the state to say, okay, if you're willing to admit what you did, and we will give you enough time to protect society, but we won't max you out. We won't give you what we could have done if you're just going to have a full trial. And so, therefore, there is an incentive for the state to move the docket along, and there's an incentive for the defendant to accept the agreement. Now, there's something called an Alford plea, where the defendant really feels that they are innocent, but the overwhelming weight of the evidence would find them guilty, and they find that it might just be too costly in terms of time, even with a public defender, emotionally costly to go for the full trial, and then they might want to do what we call an Alford plea and simply admit that there is enough evidence that would convict them, and therefore they're going to not contest it and plead guilty. Most people, though, realize that if they are in fact guilty, they're going to wind up privately admitting it to me, even though what we say is confidential. The state State doesn't know that, but they know what they've done mostly. And so you have the concept of alternative um, resolution. For example, I'll just take DUI cases. It's the most clearest example of this. If it's a first time case, then I can have that person evaluated and see whether they're a problem drinker or a social drinker. Okay. And if they are a social drinker, there'll be a short education course. If they're a problem drinker, there'll be a 6 month treatment program. But in either case, I'm trying to give them an opportunity to find another way so they don't repeat this, and society's getting that benefit. In exchange for not having the trial, oftentimes the state will give a one time forgiveness, we call probation before judgment, unless the amount of alcohol in their system is egregious. But oftentimes, we can work things out alternatively so that society's protected. We're not having drunk drivers on the road, but we're giving that person an opportunity not to permanently lose their license and to go through an education program, community service in ways that they can better themselves. So the opportunity to enter into a plea agreement will help the client, particularly the ones that are not recidivists, to uh, to find a way to reform and not have this happen again. And the state has the efficiency of moving cases along, so they're not having to try every case. And that's why you're getting roughly about 90% of the cases are settled through plea agreements as opposed to having a trial. You're more likely to have a trial with a recidivist. Because if I've DUI'd 5 times, they ain't going to be. There's only one thing. There's nobody's going to agree to nothing. And the only shot that I have as a defense lawyer is to find some technicality, or make the state prove its case. Maybe the day before trial, one of the key witnesses goes to the hospital and gets sick or something, or the officer, something happens. So your only shot really is to kind of find something technically wrong. And so you tend to have trials on the higher profile cases and also the ones that where you're done with reform and you're mainly just protecting society, and the room for alternative agreements kind of narrows. But I had a lawyer come to me one time. This is a really difficult sex offense case, and I really thought that from all along my client was really innocent. Had him take a lie detector test. It came up that he, according to that, was innocent. So I got a very seasoned trial attorney from Baltimore to do that type of case. It's a bigger case than I would normally do here, one man firm in Carroll County. He came up to me the day before trial and he confided in me. He says, "I'm nervous." So what do you mean you're nervous? You've been doing this for 20 years. He said, "Yeah, but 99% of my clients are guilty. Your guy's innocent." And he said, "Usually I just try to do, even if I'm doing a full trial, whatever, I'm trying to get the best break that I can so he can be rehabilitated or his sentence is reduced. But with your guy, everything's on the line." And he walked in the court, and the state the next day realized they did not have the case they thought they had, and the case was dismissed. If I'm a small, if you're talking to a small law firm or a sole practitioner, sometimes the best help that I can be is not necessarily whether I personally do the case, but I get that person referred to the type of lawyer that specializes, like in sex offense cases or homicides and those types of things. That with my breadth of experience, 40 years experience, I know who to refer those people to. And like the example I was giving you, my guy went scot free because they really realized that by going to trial, he would win, and they didn't want to expose that um, that risk. But you have to, if they get a attorney with less experience, they might not have the wisdom to refer it, uh, or they might have the person plead guilty when they didn't need to.
And that actually kind of brings me up to my next point and topic, which are trials itself. And the primary kind of questions that I have building onto trials, because the way you're going to present each one is going to be different depending on the client, depending on the case, how you're going about things, and how someone might do it. Is when you know a trial is going to happen for a client, what do you do to prepare a client, and what should someone expect when going into a trial for their first time? I think it's a lucky thing that most people don't have to deal with it, but for those that are going to have to go to trial and be in one, what does that look like for them and for yourself?
Well, you need to really prepare your trial thoroughly. And so you need to marshal all of your evidence and have it in the shape that you can get it introduced and authenticated. And you need to be preparing your client, as you indicated in your question. Clients are very nervous. They've never been asked usually, or if it's first time anyhow, um, to answer in a formal way where they could be subject to penalties of perjury if they're not telling the truth. And so I'll give them instructions to how to really, really tell the truth. Sometimes people think they're telling the truth, but they're really guessing. For example, if I were to ask you, how far is it from the back of your chair to the wall, what would you tell me?
I'd say, first off, that's a very good question. And I'm terrible at estimating any sort of distance, but I'll go off on a limb and we'll say 10 feet. That feels like a good number for it.
You just lied because you guessed.
Okay. Okay.
Cross examination, I will have had my Paul Drake out there with a tape measure. He's lying. He says it's 10 feet, but it's only 8 feet 6 inches. Well, if he's wrong about that, he's wrong about this, that, and the everything else. So you see, when you are dirty bound to have your client tell the truth, and if the truth is going to incriminate him, then he has the right not to testify, to not incriminate himself. But people sometimes think they're telling the truth, but what they're trying to do is please the questioner. So you wanted to please me because you wanted to give me an approximate distance from the back of your chair to the wall. And you say, well, it was about 10 feet. But I went and had my investigator show it's 8 feet 6 inches. Um, so you see, that is just one little example of how important it is that you rehearse the testimony with your client so that they are truly telling the truth and nothing but the truth. But they're not guessing, they're trying to please the questioner and so forth. Also, timelines are very important. And so sometimes people can mix things up, but if they look at the documents, what we call it is memory refreshed. If it truly they don't remember, then they're going to have to say, well, I don't remember, but this document says this. But oftentimes a cue will refresh your memory. And so you're not going to have your facts all jumbled up. And so sometimes people are very well meaning and they're trying to tell the truth, but they just, you know, they're imperfect in terms of how they remember things. And so it is just very important that you have your clients prepared. And also, you do the same thing with the witnesses. You interview them. In your higher profile cases, you're going to do this with every witness that you have and make sure that every document is authenticated. And then you have like a little trial notebook and you pull things out and you have things very organized.
I promise you don't. Next time we talk, I will have an accurate measurement for how far away my chair is from the wall. So if it ever comes up in trial, we'll know for sure, and we won't have any guessing. Well, as we come to an end, and I think has been a very good overview of the criminal process and what people can expect. Are there any topics or any pieces of advice that you would want to cover that I may not have brought up at this time?
Well, I think, again, just to make sure that the client is hiring the lawyer as soon after they're accused as possible. Sometimes they're penny wise and pound foolish, and they'll think, "Oh, I can do this myself." And then the day before trial, oh my God, I need a lawyer, and then it's really late in the game because I haven't had the proper time to do discovery, pretrial investigation, or even if I get a postponement to give me that time, memory is stale, things are stale, and so I just tell people they need to get a representation as clear as possible. They may want to interview different lawyers. As I said, I'm not the font of all information. I have a good bit of experience, and I'm more attuned to a rural practice. They may feel more comfortable with bringing somebody from the city up here to clean house, that kind of thing. So the person, the client, should feel comfortable with the lawyer that they're hiring, and they should hire a lawyer that has a good reputation. They can go on Google or they can go on lawyers, LAWYERS.com, which is the peer review system that most lawyers recognize. It comes from the old Martindale Hubble, um, and that's all part of LexisNexis, I believe. But it is a very reputable source for selecting lawyers. So you can look at the Google reviews. It's very sophisticated now in terms of finding somebody. And one of the reasons we're doing the video today, so that people can get a feel for who they're hiring before they walk in the door and they're feeling comfortable with that lawyer. And to not hold anything back from the lawyer, they're shame, shame, shame. They're ashamed to say that they did this. Um, Sometimes, maybe the sexual assault cases or whatever. Tell me the gory details, because if I know that the state can prove that, I'm going to advise my client differently than if they're withholding something from me and then it pops out at trial. So I think the most important thing is to have a good rapport with the attorney, to be prepared, and to be thorough on both sides, both on the side of the client and the side of the attorney, um, and to present their case. But to get legal representation as soon as possible.
I think that's great advice, and I hope that anyone listening and watching definitely takes it to heart, and definitely, if you ever need to hire a criminal attorney, and everyone always hopes that you don't, hire one as soon as you can, and don't hold back with any of the information because they need to know everything to best defend and prepare for your case.
That's it.
I think that is a good stopping point. So I think that's where we'll stop and end this video here. But not to worry, there will be many other videos that we'll be releasing with many other topics to cover. So Don, thank you for your time and for giving us this great overview of the criminal process for Maryland.
You're welcome.